Case number 6, osteoarthritis. Franciviel Denama Sestoso versus United Philippine Lines Incorporated. Carnival Cruise Lines Fernandino Lising. GR number 237063, Second Division of the Supreme Court, promulgated July 24, 2019, per Justice Lazaro-Javier. Sestoso worked as a head waiter in a ship. His task includes cleaning table. One day when he knelt to clean the dining table, a sharp pain radiated down his right knee. Magnetic resonance imaging, or MRI, test in California revealed he has a complex tear of the medial meniscus and a degenerative joint changes. When he was repatriated in the Philippines, he was diagnosed with osteoarthritis and medial meniscal tear in the right knee. Sestoso then filed a claim for compensation. The labor arbiter ruled in favor of Sestoso. The NLRC affirmed the LA. The Court of Appeals reversed the NLRC. The issue in this case is Sestoso's illness, osteoarthritis, work-related and compensable? The Supreme Court ruling said yes. Osteoarthritis is listed as an occupational disease, which is presumed to be work-related. Under Section 32A 21 of the 2010 POEA-SEC, Philippine Overseas Employment Administration Standard Employment Contract, for osteoarthritis to be considered as an occupational disease, it must have been contracted in any occupation involving joint strain from carrying heavy load or unduly heavy physical labor, as among laborers and mechanics, minor or major injuries to the joint, excessive use of constant strenuous usage of a particular joint as among sportsmen, particularly those who have engaged in the more active sports activities, extreme temperature changes, humidity, heat and cold exposures, and faulty work postures or use of vibrating tools. Supreme Court cited Centennial Transmarine Incorporated versus Kiambao, 763 Phil 411 424 425 in the year 2015, where this court decided or ruled that the seafarer was diagnosed with osteoarthritis. The court ruled that since the seafarer's work involved carrying heavy loads and performance of other strenuous activities, it can reasonably be concluded that his work caused or at least aggravated his illness. Petitioner was awarded US $60,000 or its equivalent in peso at the time of payment, 10% attorney's fees. It's not written here, but the court also awarded a 6% interest from the time the payment is due until it is paid, 6% per annum. In More Maritime Agencies Incorporated versus NLRC, 366 Phil 654 655 in the year 1999, cited by the Supreme Court in this case, the court held that compensability of an illness or injury does not depend on whether the illness or disease was pre-existing at the time of employment, but rather on whether the injury or illness is work-related or has aggravated the seafarer's condition. This means that it does not matter that the petitioner had osteoarthritis before he was employed. What mattered was that his employment aggravated his illness, thus his illness is compensable. The word permanent disability has a legal definition. It is the inability of a worker to perform his job for more than 120 days, regardless of whether he loses the use of any part of his body. As is visible here, the word permanent disability does not indicate absolute helplessness. It just indicates the inability of the person to perform his work for more than 120 days. On the other hand, total disability means the disablement of an employee to earn wages in the same kind of work of similar nature that he was trained for or accustomed to perform, or any kind of work which a person of his mentality and attainments could do. So it is wrong to argue that a seaman who has osteoarthritis could work as a vendor of, say, fishbowl, to argue that he is not totally disabled. The word total disability in this case has a legal definition, and the fact that a seaman can no longer perform his work as a seaman entitles him to total disability benefits. The lesson from this case is that this case affirms the fact that strenuous repetitive activities and heavy workload, like the work of a seaman, can aggravate or cause osteoarthritis. The unauthorized use or reproduction of this work will be prosecuted under the Intellectual Property Code and other laws.